The human rights. The United Nations have defined the human rights as rights inherent to all human beings, regardless of their race, sex, nationality, ethnicity, language, religion, or any other status. Human rights are universal, inalienable, which means that they should not be taken away except in certain situations, indivisible, that is, inherent to the dignity of every human being, and interdependent, which means that the improvement of one right facilitates advancement of the others, and the deprivation of one right adversely affects the others. Human rights are equal, as it is said in Article 1 in Universal Declaration of Human Rights. All human beings are born free and equal in dignity and rights. The rights are also non-discriminatory, which basically means that everybody is equally entitled to human rights without discrimination. Above all, they are both rights and obligations. Human rights are applicable only in the time of peace. In the time of war, the source of regulations is the humanitarian law. The human rights have gotten their inspiration from morality, justice, ethics, and a simple regard for the dignity of mankind. The purpose of human rights is to ensure that individuals are protected from the excess of states and governments. Law of human rights is an exception to the absolute and exclusive territorial jurisdiction of states. Before the United Nations Charter, individuals were not a major concern of international law, and national law didn't provide protection either. The creation of the United Nations in 1945 meant the beginning of the development of one of the most significant advances of international law from then on, the protection and development of human rights. The United Nations Charter states as one of its purposes to reaffirm faith in fundamental human rights, and the UN has committed to promoting universal respect for and observance of human rights and fundamental freedoms for all. Members of the United Nations commit to cooperate to achieve the purposes of the Charter relating to human rights. The Universal Declaration of Human Rights. The Universal Declaration of Human Rights, written in 1948 by an international committee, wasn't intended to create binding legal obligations, but to urge states to establish procedures for the future protection of human rights. The declaration is said to be a standard by which the behavior of states, ethnic groups, individuals, and multinational corporations are judged. It lays the basis for modern international human rights law and lists 30 articles recognizing we are all born free and equal, the right to life, liberty, and personal security, no torture, right to a fair trial, freedom of movement, freedom to seek asylum, freedom of thought, conscience, and religion, freedom of opinion and expression, right to democracy, right to education, among other things. The International Covenant on Civil and Political Rights. The International Covenant on Civil and Political Rights was created in 1966 and it is a legally binding document. The Covenant contains first-generation human rights, that is, civil and political rights at the core of most human rights treaty regimes. It contains similar civil and political rights to those found in the Universal Declaration of Human Rights. For example, the right to life, the prohibition of torture and slavery, and the right to liberty of the person. The Covenant provides for the possibility of individual or interstate complaints to the Human Rights Committee. When an interstate complaint is referred to the committee, it will attempt to mediate in order to achieve a settlement. If a settlement is not achieved, the interstate complaint can be further referred to an ad hoc conciliation commission. The reports of the committee or the conciliation commission are not legally binding. However, this possibility of individual and interstate complaints is optional, so the states have the right to choose whether they accept complaints. The International Covenant on Economic, Social and Cultural Rights. The Covenant was also created in 1966. It is the counterpart to the Covenant on Civil and Political Rights, and like that covenant, the Covenant on Economic, Social and Cultural Rights is also legally binding. It contains second-generation rights, that is, rights relating to matters of social and economic significance, and rights of more amorphous nature to first-generation rights. The enforcement mechanisms of second-generation rights are more flexible and less powerful than the ones of first-generation human rights. At first, there wasn't possibility of complaints, but after the adoption of the optional protocol in 2008, the right to individual or group petition to the Committee on Economic, Social and Cultural Rights was established. The European Convention on Human Rights and Fundamental Freedoms. The Convention represents a comprehensive statement of the civil and political rights believed to be common to the peoples of Europe. It is open to signature by all members of the Council of Europe. The Convention contains similar provisions to the International Covenant on Civil and Political Rights, even though its provisions for enforcement are more effective. State parties to the Convention are obliged to protect the human rights of any person within their jurisdiction. Many states have incorporated the Convention into their national law to fulfill their obligations. The general purpose of the Convention is to fill possible gaps in the domestic law, not to prevent or punish violations. Parties to the Convention automatically accept the right of other state parties and individuals to bring a case to the European Court of Human Rights. Procedure for bringing a claim. The procedure proceeds as follows. The admissibility of individual complaints is decided by a single judge or a committee of the court, which contains 3 judges, and the admissibility of interstate complaints by a chamber. Admissible applications are open to friendly settlement, but failing to reach a settlement, the complaint is referred to the chamber, and in exceptional cases, the decision of the chamber can be referred to the grand chamber. The judgment of the chamber or grand chamber is final, and the Committee of Ministers supervises the execution of the judgment. There are also other regional systems in addition to the European regional system, for example, Inter-American Convention system and African Charter system, but there haven't been that great advances in the systems outside the European regional model.